Now, at American common law, manslaughter was defined as the unlawful killing of a human being by another human being without malice aforethought. In other words, the only difference between murder and manslaughter at common law is the presence or absence of malice aforethought. At common law, manslaughter was itself divided into two categories, voluntary and involuntary. At original common law, the punishment for voluntary and involuntary manslaughter was exactly the same. That's why there aren't degrees of manslaughter. You're not talking about a more and less serious crime at common law. But today, states that divide murder into these two categories treat voluntary manslaughter as a more serious offense than involuntary. All right, what constitutes voluntary manslaughter? At common law, this form of manslaughter has come to be known as the sudden heat of passion manslaughter, or the provocation form of manslaughter. In almost every case, the defendant intended to kill the victim, so the case would constitute murder, unless the defendant can prove that his case falls within the doctrine of heat of passion. There are three elements to this so-called heat of passion manslaughter, each of which must be proven in order for a defendant to avoid conviction for murder and instead be convicted of voluntary manslaughter. The first element, and usually the most litigated, is that the defendant must show that he killed because of adequate provocation. That's the crucial term, adequate provocation. We'll come back to that. Second element, the killing must have occurred during the heat of passion, that is, before the person's passion is cooled off. And third, that heat of passion must have occurred before the actor had a reasonable opportunity to cool off. Those are the three elements to prove voluntary manslaughter. Adequate provocation, the person kills during a state of passion, and the person didn't have a reasonable time to cool down. Now, your classic common law example of voluntary manslaughter was the husband who walks into his home, suddenly out of nowhere observes his wife in an act of adultery with a third party. He becomes suddenly enraged and kills his wife's lover. It's an intentional killing, so it's murder, unless we meet the three elements. Adequate provocation, well, seeing the adultery. Passion, he was angry when he killed. And third, not enough time for an ordinary person in the same situation to cool off. He killed, in this case, in my hypo, as soon as he saw the adultery. No time to cool off, therefore, murder becomes voluntary manslaughter. Well, why would we reduce an intentional killing in these circumstances to manslaughter? To answer that, we have to look at the first element of heat of passion manslaughter, that is, adequate provocation. The common law basically felt that a provoked actor's degree of culpability is less than for murder if he's been adequately provoked to kill. Okay, so what is adequate provocation? At common law, it was provocation that might render an ordinary person of average temperament liable to act irrationally and thus without due deliberation. In other words, adequate provocation is provocation that would cause an ordinary person to respond out of passion rather than out of reasoned judgment. It's a provocation that would make an ordinary person with an ordinary temper, not a short temper, but an ordinary temper, liable to become violent. Now, you'll notice that sometimes I talk about the ordinary person, but you will often see courts use the term, in this context, reasonable person. In other words, provocation that would cause a reasonable person to act out of passion rather than judgment. I prefer to talk about this individual as an ordinary person because it's kind of hard to think of a reasonable person acting out of passion rather than out of reason. But what we're really saying is, look, this provocation was so bad that you or I, or even an ordinarily reasonable person, might, not necessarily would, become so impassioned that they would lose their self-control and perhaps act violently. Now, I need to warn you that at original common law there were only certain categories of provocation that were considered adequate, and thus would meet this first element of the heat of passion doctrine. And if you couldn't fit into one of those pigeonholes, you weren't entitled to claim adequate provocation and thus couldn't get your homicide reduced to manslaughter. The first category of adequate provocation was a man observing his wife in an act of adultery. Key point here, the person had to observe the adultery. Simply being informed about the adultery, well, that wasn't enough. And I stress that at original common law, it involved a man observing his wife and not vice versa. The law was very sexist. Second, observing the seduction of one's young daughter was treated as adequate provocation. And third, a serious battery could constitute adequate provocation. These were the categories of what the common law considered adequate. On the other hand, the common law was very clear that words alone never, ever constituted adequate provocation. It doesn't matter at common law what the words were, how insulting they were, or whether the person uttered a racial epithet. It just didn't matter. Similarly, if the person provided information to the defendant that might arouse anger, such as, "I slept with your wife last week and boy was that fun," those are words. Words alone would never do. Now, that particular common law rule, that words alone are not sufficient, persists today in the United States. On the other hand, the law today is not limited to 3 or 4 or any other number of specific categories of common law provocation. Courts today will generally instruct the jury on the definition of adequate provocation. That is, again, provocation that would cause a person of ordinary temperament liable to act out of passion rather than reason. And then they'll let the jury decide if the provocation in the given case was adequate. But again, words alone would never qualify. All right, that's the first element to reduce murder to manslaughter, that the provocation must be adequate. But that's not enough to reduce it to manslaughter. If a person was adequately provoked, but then coolly and calmly killed the victim, well, it didn't suffice. The killing must occur while the defendant is in a state of passion. Now, by the way, that passion, that emotion, doesn't have to be anger. It could be jealousy or any other extreme emotional response, but there must be passion. And finally, third, there must not have been time for a reasonable person of average temperament to cool down. And courts have usually been pretty strict in this area, even, if you will, psychologically unrealistic. So if a person is provoked and he thinks about the provocation and he mulls it over and he spends hours thinking about it, getting angrier and angrier and angrier until he finally explodes and kills the victim, well, yeah, there may have been adequate provocation, and yes, the defendant did act in passion, but the common law would say, hey, a reasonable person would have cooled down in that hour, would have gotten back his capacity for reflecting thoughtfully and reasonably, and therefore that the person had a reasonable opportunity to cool off, in which case the heat of passion doctrine is lost and the crime remains murder. So again, what we're dealing with is an intentional killing, which would normally constitute murder, reduced to voluntary manslaughter if the defendant kills intentionally as a result of adequate provocation while in a state of passion and before a reasonable person in the actor's situation would have cooled down. Now, some jurisdictions, those that follow the model penal code, today apply a much broader version of heat of passion than what I've just described. The model penal code, first of all, doesn't call it voluntary manslaughter. It just calls the offense manslaughter. And it states that a killing that would otherwise constitute murder, that is, a killing committed purposely, knowingly, or recklessly, manifesting an extreme indifference to the value of human life. We talked about that a little while ago. Any killing that would constitute murder, which occurs as a result of, and here's the language of the model penal code, the result of extreme mental or emotional disturbance for which there is a reasonable explanation or excuse. Now notice we're not dealing here with, quote, heat of passion, but rather with, quote, extreme mental or emotional disturbance. For example, there's a New York case, People versus Casasa. And Casasa was a man deeply in love with his girlfriend. She broke up with him. He, in turn, broke into her house while she wasn't there, and he waited for her to come home because he wanted to convince her to continue the relationship. In fact, he brought her some gifts. When she came home, she rebuffed him again and rebuffed his gifts and told him to get out of the house, and he killed her. Now, could that possibly constitute adequate provocation at common law? I don't think so. I mean, what's the provocation? That a woman tells a man to whom she's not married to get out of her apartment that he broke into? Or for a woman to tell a man to whom she's not married that she doesn't love him and doesn't want his gifts? That could hardly constitute adequate provocation at common law. But the Model Penal Code would ask a different question. The question wouldn't be whether she provoked him. Notice that that term isn't even mentioned in the code. And wouldn't be asking whether this was adequate provocation. The first question would simply be, was the defendant at the time of the killing experiencing an extreme mental or emotional disturbance? Well, in this case, he was very emotionally overwrought, and therefore he would meet that first criterion. That would lead us to the second part of the Model Penal Code definition. If the defendant is experiencing extreme mental or emotional disturbance, then the jury must determine whether there was or was not a reasonable explanation or excuse for that mental or emotional disturbance. Now understand, this is something students often forget and make the wrong statement on exams. Understand that the question for the jury is not whether there was a reasonable explanation or excuse for the killing. Clearly, there is no reasonable explanation or excuse for the killing under the circumstances I've just described. The question is simply whether or not there was a reasonable explanation or excuse for being in that emotionally overwrought condition. If the jury says no, he's guilty of murder. If the jury says yes, there is a reasonable explanation or excuse for this emotional condition, then it's manslaughter under the Model Penal Code. Okay, so we've discussed what the common law would call voluntary manslaughter, heat of passion. At common law, again, it requires adequate provocation, killing while in passion, and not enough time to cool off. And the Model Penal Code uses a broader test that talks about extreme mental or emotional disturbance for which there is a reasonable explanation or excuse. Now, at original common law, that was it. That was the only basis for reducing murder to voluntary manslaughter. But over time, some states, by judicial opinion, developed another basis for reducing murder to manslaughter, and that's the doctrine that we've already talked about, namely diminished capacity. You'll remember that we talked about it, and I said that there were two versions of diminished capacity. One was the mens rea version, which really just means that the person lacked the capacity to form the specific intent in a particular crime because of some mental abnormality. But I also spoke of another version, the so-called partial responsibility version of diminished capacity, which can reduce murder to manslaughter if the defendant can show that he killed as a result of diminished capacity. In other words, some mental condition, not extreme enough perhaps to constitute insanity, but which makes the defendant less morally culpable for the homicide. And you can go back to the earlier part of this lecture to review that concept. I would also point out that the Model Penal Code also recognizes this form of diminished capacity because that extreme mental or emotional disturbance language that we just talked about is meant not only to cover the heat of passion type cases, that would be an extreme emotional disturbance, but also deals with mental disturbances. There is our diminished capacity, for which there is a reasonable explanation or excuse. So in other words, if a jury finds that the person is suffering from some mental disturbance or low IQ or a mental illness not sufficient to constitute insanity or some brain damage, and if there is therefore a reasonable explanation or excuse for that condition, then the killing, which would otherwise constitute murder, is reduced to manslaughter. Okay? So, there are these two forms of intentional killing that might reduce a crime from murder to manslaughter, or what the common law would call voluntary manslaughter. Heat of passion in all jurisdictions, diminished capacity in some jurisdictions. And the Model Penal Code has the concept of extreme mental or emotional disturbance, for which there's a reasonable explanation or excuse, which covers very broadly both heat of passion and diminished capacity. Okay, so much for voluntary manslaughter. And by the way, turning again for a moment back to that bugaboo, the exam, if you have a case in which murder is the issue, the person has been charged, in other words, with murder, you should always consider manslaughter as a possible area for discussion on the exam. That's because in the real world, when a prosecutor charges a particular crime, if there is evidence that would support convicting the defendant instead of a less serious crime than that for which he was charged, then the jury is permitted to return a verdict for that lesser crime. A jury can never come back with a verdict higher or more serious than the crime charged, but the jury may come back with a verdict to a lesser crime. So, for example, if a person is charged with, let's say, first-degree murder, in other words, the prosecutor claims, let's say, that the defendant killed intentionally and premeditatedly and with deliberation. But suppose the defendant killed the victim but did it quickly, so that maybe it wasn't premeditated. Well, then the jury could return a verdict of second-degree murder. Or suppose that the intentional killing was the result of provocation. Then, although the charge may have been murder, the jury could reduce it to voluntary manslaughter. So be prepared to talk about lesser crimes if the facts support such an argument. Okay, we've talked about murder. We've talked about voluntary manslaughter. Now we turn to so-called involuntary manslaughter. At common law, there were two kinds. First, a killing that occurs as a result of criminal negligence, or what some states by statute might simply describe as, and I quote, commission of a lawful act which might produce death, committed in an unlawful manner without due caution and circumspection. I'm giving you that long language because you will find it in some statutes, and it comes directly from the common law, from Blackstone and elsewhere. The commission of a lawful act which might produce death, committed in an unlawful manner without due caution and circumspection. Well, that's basically saying that what the person was doing was an otherwise perfectly lawful act, but he did it in a dangerous way, i.e., in a criminally negligent manner. So, a criminally negligent killing at common law constitutes involuntary manslaughter. Now notice that there's a very fine line between the kind of conduct that would constitute involuntary manslaughter, negligence, and the kind of risk-taking that would constitute murder, depraved heart. If a person's conduct manifests an extreme indifference to the value of human life, in other words, we're dealing with extreme recklessness, well, that's murder. If the conduct doesn't manifest extreme indifference to human life, then it may be criminally negligent, in which case it's manslaughter. Usually, the difference between murder and manslaughter at common law is whether the defendant was aware or unaware that he was taking a very substantial and unjustifiable risk. If he was aware and went ahead anyway, well, if he had that I don't give a damn attitude we were talking about before, then that constitutes recklessness, that constitutes malice, that constitutes murder. If it's a case, however, where the person simply wasn't aware, but should have been, that he was taking that substantial and unjustifiable risk, that would constitute criminal negligence, and that would constitute the lesser offense of involuntary manslaughter. Now, there's a second type of involuntary manslaughter at common law, sometimes called the misdemeanor manslaughter rule, sort of the equivalent of the felony murder rule. Felony murder, misdemeanor manslaughter. But more accurately, this shouldn't be called misdemeanor manslaughter, even though courts often do. It's better to call it the unlawful act version of manslaughter. Simply put, an unintended homicide that occurs during the commission of an unlawful act not amounting to a felony constitutes involuntary manslaughter. Again, an unintended homicide that occurs during the commission of an unlawful act not amounting to a felony constitutes common law involuntary manslaughter. So it looks very much like the felony murder rule, except that instead of a felony, you have some other kind of unlawful act. Most of the time, that unlawful act will be a misdemeanor, but at common law, the term unlawful act in this context could mean a morally wrongful act that isn't criminal. In other words, any morally wrongful act that leads to an unintentional death would amount to involuntary manslaughter. Let me give you a couple of examples. Driver doesn't stop at a stop sign. He sort of slowly rolls through the intersection. Have you ever done that? He doesn't come to a complete halt. Well, that's an unlawful act in the sense that you could properly receive a traffic ticket for failing to operate your car in accordance with a traffic regulation. And if you were unlucky enough to have a police officer in the vicinity, you might get that ticket. Well, suppose your car rolls through that intersection without coming to a complete halt, and a child jumps out in front of the car out of nowhere, unexpectedly, unforeseeably, and you hit the child, and the child dies. It's not an intentional killing, not a reckless killing. You didn't manifest extreme indifference to the value of human life. You just rolled slowly through the stop sign, the way all of us do on occasion. And it might not even be a negligent killing, because remember, the child jumped out of nowhere. But it would be involuntary manslaughter, because it was still an unlawful act that resulted in a death. So again, two forms of common law involuntary manslaughter: a killing that is a criminally negligent killing, or a killing that isn't even negligent, but is the result of and occurs during the commission of any unlawful act not amounting to a felony. Now, the Model Penal Code has a different version of manslaughter. There are two versions of manslaughter. One we've already mentioned, that's the extreme mental or emotional disturbance version. The other version of manslaughter under the MPC is a killing that occurs recklessly. Now, wait a minute. I also told you that recklessness constitutes murder under the Model Penal Code. But under the Model Penal Code, the murder form is recklessness manifesting an extreme indifference to the value of human life. But if the person kills recklessly and doesn't manifest an extreme indifference to the value of human life, then it is only manslaughter. So, virtually any case of reckless murder could be reckless manslaughter. It'll be up to the jury to decide, if you will, how extreme the reckless conduct was. All right, but, well, what about the two forms of manslaughter that I told you constitute involuntary manslaughter at common law? Remember, criminally negligent killing and a killing during the commission of an unlawful act? Well, first, if a person negligently kills another person, not recklessly, but negligently, the Model Penal Code drops that to a still lower crime, lower than murder, lower than manslaughter. They have created a new crime called negligent homicide. So they've taken criminal homicide, and unlike the common law that divided it up into two crimes, murder and manslaughter, the MPC has three crimes: murder, manslaughter, negligent homicide. So a criminally negligent killing, involuntary manslaughter at common law, is negligent homicide under the MPC. And as for that unlawful act type killing, well, the Model Penal Code has abolished it, period. You crawl through a stop sign, you kill that child, if the prosecutor can't prove you acted at least negligently so as to convict you of negligent homicide, well, then you wouldn't be guilty of any form of criminal homicide. Okay, that's our basic discussion of murder and manslaughter. Again, common law murder is a killing of a human being by another human being with malice aforethought. We saw that there are four states of mind that qualify for malice aforethought: intent to kill, intent to commit great bodily harm, the abandoned or malignant or depraved heart, something we might call extreme recklessness, and felony murder. At common law, there were two versions of manslaughter: voluntary and involuntary. Voluntary involved heat of passion, and today in some jurisdictions, diminished capacity. Involuntary manslaughter, there were two forms at common law: criminally negligent killings and the unlawful act or misdemeanor manslaughter doctrine. And the Model Penal Code, you will remember, states that murder is a killing committed purposely, knowingly, or recklessly, manifesting an extreme indifference to the value of human life. Manslaughter, in turn, is a reckless killing without that extreme indifference, or a killing that occurs as a result of extreme mental or emotional disturbance for which there's a reasonable explanation or excuse. And the Model Penal Code has that third crime, negligent homicide. And finally, remember, with murder, you'll likely deal with a statute, and if you have a statute, look at it, see if it divides murder into degrees, and if it does, you'll need to talk about first-degree murder, for example, a killing that was willful, deliberate, and premeditated. But you'll also need to consider second-degree murder, because second-degree murder typically includes every kind of common law murder that isn't expressly covered in the first-degree murder statute.